We are tracking developments in the trial of 3 Tacoma police officers in the death of Manuel Ellis. Thanks for joining us. I'm Christine Pay. Ellis died while being restrained by police in March of 2020. Officers Matthew Collins, Christopher Burbank, and Timothy Rankin are all facing charges in his death. King 5 is live streaming the entire trial from opening to closing statements. We take you now to the courtroom live.
In terms of our schedule?
Yes, Your Honor, we had an opportunity to meet and confer yesterday, and based on the court's current rulings, the state is expecting to remain rest as early as this Wednesday, or at the latest by next Monday. We let the defense know that. I'll let the defense speak to their case, but what they relayed was that they expected they could put their case on in approximately 10 court days, or by the end of November. I think is what we were counting, assuming, as we understand it, there's only 2 days of court the week of Thanksgiving. So that's where we currently are.
That would be right about that week of Thanksgiving. Also, we're looking at more like our estimated time of December 4th or so for folks after all. Okay.
Yes, correct. Yeah. The state was anticipating more than that, obviously, but that's currently where we are.
Of course, that would depend as well if they're going to put on any type of rebuttal case. That's our current rough estimate.
Judge, I would anticipate that we're going to go in the defense case, just given that there are only two court days that week of November, that will likely go into that first week of December. Just out of caution, I don't want to underestimate, but...
Sure. Well, we had at least one, I think I may have mentioned this too, one of the jurors is trying to schedule something that would take them away the week following Christmas.
Yeah.
We're given the court's ruling, we're also going to meet and try and figure out witnesses so that we're not producing cumulative evidence, and that it's going to be a defense case that's to the point.
That's good. All right, well, I guess you can tell the jury they can probably schedule their visit. We still think it's going to be done by the middle of December. Okay. Then there was a motion to compel production of discovery with respect to, I guess it's,
Remember, the state hasn't had an opportunity to look at the motion. I think it was just filed this morning, so we'd asked to take it at a later time. It relates to a defense expert. I have to look at what the allegation is and what the document is that counsel is complaining about.
Yeah, I'm not sure what this is about either, to be honest with you, because Mr. Conrad launches into all the stuff that the AG is supposed to do, and then at the very end, I see that the AG is redacted what appears to be a previous report from defense expert Dr. Jennifer Stankus as work product. So this is so Dr. Stankus is, as I understand it, a medical doctor who is potentially being called by the defense.
Correct.
And there was an attachment here of her CV, and also attached to that was about 3 or so pages like this, blanked out, says work product. So the only question, as I understand it then, is what are these, I guess it's almost 4 pages. What's on these 4 pages, it's work product, and is it really work product, I suppose? That's your mission, I think, Ms. Eakes, is that what we're talking about?
Well, that's just one example. I mean,
Was there something else that we're talking about?
well, I think if the state intends on using, I don't know if they've been able to get any other reports or anything like that regarding any experts that we intend on using, but my concern is that the state is holding information back that they intend on using, either as impeachment or on cross-examination of experts, and I mean that information needs to be turned over. It's not this surprise game. We haven't done that. The prior expert report that we used with Dr. Wilgenertner, we received from the state themselves, and it was apparent that we had that. Aside from that, I mean, this isn't supposed to be a game of blind man's bluff, especially not in a criminal case. And so I just want to avoid being surprised by any information that the state's been able to gather. And so I'm asking that the court compel them to produce that information. And so that was just one example.
So this has to do with all the defense experts.
Correct.
All right, so Ms. Eakes, when do you think you might be able to respond to all this?
We should be ready to discuss it tomorrow morning.
Is that gonna work?
Yes, sir.
Okay. Did you guys want to say something?
Just real quick, Your Honor, as you recall, we didn't give an opening for Officer Collins, reserved that. I'm just looking for a little guidance from the court in terms of PowerPoints and being able to show documents that have been admitted in my opening. So I don't know where the court stands on that.
Well, if it's a document that has been admitted, you can refer to it.
Okay. Can I put it on PowerPoint?
Yeah. How you can display it, if that's what you mean.
Okay.
I don't know what else you're gonna have in your PowerPoint.
Well, it'd be pretty straightforward. I'm happy to give the state a copy before.
You should.
Okay, will do. Thank you.
Great.
I guess the only concern I'd raise, Your Honor, is that the court wouldn't allow any of the other parties to have any PowerPoints for opening statements. So
Yeah, because those weren't admitted exhibits.
Right, but even the illustratives that were on the PowerPoint, the court wouldn't allow.
That's right.
Is the court going to allow, it sounds like the court's now going to allow Collins to have a PowerPoint regardless of whether it's admitted exhibits or not?
I didn't say that at all.
That's what I'm asking for
The
clarification.
question had to do, he's gonna have a PowerPoint. You could have had a PowerPoint too if it had not been necessary to redact so much of it. And then it was gonna be, well, okay, we'll do these redactions, it's gonna take us another 15 or 20 minutes. I said, I'm not waiting for it. So move ahead now. There was nothing wrong with the PowerPoint in and of itself. The PowerPoint had not been otherwise objectionable, which it was on both sides, and so nobody got to use their PowerPoints during their opening, except, as we say, that Mr. Urbans and his wisdom is reserved his opening statement, which is neither here nor there about how wise it is. But now that it's an admitted exhibit, there's no reason why you can't use it and disclose it to the jury. But it's got to be an opening statement, not a closing argument. Okay. Mr. Fricke, I think you looked like you wanted to say something.
I did, Your Honor. If we're moving on to the next witness, which is Jack Ryan, their expert on police practices, use of force. And in his report, in his interview, and he's in the courtroom, I believe, if I'm not mistaken here, but they've marked a bunch of exhibits, including, we've discussed this in prior hearings, our clients training in North Carolina. I can tell, in Mr. Ryan's interview, he's indicated, and I'll just quote, in relation to other training, he says, certainly I wouldn't expect them to employ training, for example, from the military or from some other job that they were at or something like that. And saying, in essence, they should be relying upon the training they got, in this case, of course, the state of Washington and the city of Tacoma. So, in addition to that, throughout his report, he cites the national standards. And I think the court, in prior motions in limine has ruled, it's got to be training in Washington, and we want to make sure the opinions and testimony that's going to be given here momentarily is couched in the training that I think I can speak for everyone, but certainly our client has received in the state of Washington.
Well, I don't want angels dancing on the head of pins here. I mean, if the same training, if it's a national standard that says X, and the Washington standard says X, I don't think it makes much difference, does it? Except he doesn't say the word Washington training, he says national training. It doesn't matter, they're the same thing. Have you got any particular points of dispute with Mr. Ryan with respect to a training standard that he's employing that's a national standard that is not being used in the state of Washington? Or not being used in the city of Tacoma?
I guess I'll do it on a case by, or a question by question basis when it comes up, if that's what you're referring to. I would agree that if there was some, if they're identical, verbatim, for instance, he will testify to the, what's been called the Graham standards, and that's taught in the state of Washington. It's part of the academy there. So obviously and the Graham is based on a case out of the U.S. Supreme Court. So, I mean, that's going to be the same regardless of who did the training, you know. So I would not have an objection to that, for instance.
Mm-hmm.
But if there's some nuance that's different between whether it's North Carolina for our client and the state of Washington, the city of Tacoma, then that's another matter, obviously.
You'll be prepared to make an offer of proof that it's different here?
Are you prepared to object and presumably make an offer?
Well, one would hope it's based on something substantive. Mr. Usher.
Good morning, Judge. I have some of the same concerns that Mr. Fricke. I'll be more specific, though. Mr. Ryan, in his report, paragraph 54, he says that based on his training experience and training on law enforcement practices nationwide, that the neck restraint used by Officer Collins was contrary to general accepted policies. That's not. It's not contrary to the Tacoma Police Department policies. In fact, Exhibit 301 lists the hierarchy of use of force allowed, which says they can go even outside policies depending on what the officer's faced with out on the street. And so I have an objection saying an LVNR is generally accepted against nationwide policies when it's not adverse to TPD policies. He does the same thing in paragraph 60, where he says, based on his training and law enforcement practices nationwide, that the taser deployments used on this trail were contrary to generally accepted policies and practices. It's not. It may be nationwide contrary to policy. It's not adverse to TPD policies. They have a hierarchy of use of force relative to the subject's reaction and taser application and The use of force is outlined in that. It's consistent with the policy. And there's also a caveat in Tacoma Police Department policy that they're not bound by those. They can actually deviate from policy where necessary based on the officer's belief in the circumstances. So I object to the nationwide and generally accepted components of those specific opinions of Mr. Ryan.
Okay. Mr. Calabro, response?
Your Honor, on the 2 paragraphs that defense counsel officer just brought out, those are certainly areas for cross-examination. However, as he pointed out, when necessary, and the necessary standard is a national standard, and it's national standard for the use of force, and it's also consistent with the TPD use of force. Further, it's a matter of what's a reasonable officer. It's not just subjective to each defendant on when to utilize it. So yes, it does allow for an area to cross-examine, but it's also consistent with the national policy and policies against on the use of force, and that has to be reasonable and it has to be necessary. So he can't, and I anticipate his testimony will be in this case that the LVNR, the application of the LVNR by Defendant Collins was an excessive use of force given the circumstances of the case.
Well,
Go ahead.
You were going to say something else?
I also anticipate that defense will, cross-examine as he did in the interview about concerns for safety, officer safety, and threats that they're faced with if it can be utilized. And as Mr. Ryan said in the interview, yes, it can be utilized, but it has to be reasonable and necessary.
So he's going to opine that it was not reasonable or necessary here?
Correct.
Well, at least with respect to the LVNR, I can kind of get that because it obviously cuts off Mr. Ellis's airway. With respect to the taser, I don't think there's anybody that's saying that's contributing, that in any way contributed to the death of Mr. Ellis.
It increased the heart rate, Your Honor, and it also increased the need for oxygen.
Yeah.
In addition to that, you look at the totality, and you have the LVNR and the taser being utilized at the same time, and you look at the threat, where the ground factors and under the Tacoma Police Department use of force, you look at the threat the officers were facing, and that was an excessive use of force, and that's against their policy and against their training.
Yeah, but that doesn't answer it only partly sort of answers my question, which has to do with whether the taser had anything to do with the cause of death here. You're saying, well, it increased his demand for oxygen. We did get testimony as to that.
And it's also clear that using a taser with the intended application of it, and what happened in this case, is it goes to the underlying felonies for the felony murder of the assault 2 and potentially the assault 3.
Well, I don't think it works for assault 2. The LVNR might, certainly.
Question before that, Your Honor, also is whether or not the contact that they had with Mr. Ellis was lawful. And if the evidence proves that it wasn't lawful, then the taser deployment, all 3 of them would not have been lawful either.
Well, frankly, there's precious little evidence of that at this point. Because the civilian witnesses who had an opportunity to observe anything didn't see the very beginning of this, basically.
But Your Honor, even if they, well, that's if the court finds the defendant's account credible. And if the
Well,
jury finds it,
hold on a second. So there's one more sort of subtle aspect to this. It isn't enough that the jury might disbelieve the defendants. The state has to offer affirmative proof with respect to what the motive was, if you will, for the stop, to show that it was an unlawful stop. I mean, these are police officers. they're entitled to use a certain amount of force for people if they're trying to effect an arrest. There's nothing so far from the state's case that says that what the defendants are saying about why they had to do what they did was not true. Now, the jury doesn't have to believe the defendants, but the state has to show affirmatively what did happen. And I haven't heard anything yet.
And I think based on the timing and the limited amount of time that was not videoed and the timing when it coordinates with the defendant's statements and the videos, there is only a few seconds in which video was not occurring. And the Seth Cowden and Keon Lowry and Sarah McDowell all testified about seeing Mr. Ellis on the sidewalk and not in the intersection. They also testified to seeing Keon and Sarah McDowell testified to seeing the door check, which is corroborated with Defendant Burbank's statement in which he admits to doing the door check. And Mr. Cowden testified to seeing the door open and couldn't see Mr. Ellis particularly go down, but he did see. So that's all the timing issue, which would allow for, prior to that, a consensual contact, but would not allow for a either a Terry stop or an arrest at that point. Now, certainly if the jury disregarded that testimony, then there's a different account. But even if the jury disregards that testimony and the court looks at, well, was the Terry stop reasonable or was the probable cause sufficient for the arrest? I anticipate through Mr. Ryan's testimony that there's a point in the contact when, and that includes the taser, and it includes the LBNR, that there is no evidence of a threat that would warrant either of those uses of force.
Well, the first non-police person to have any perception of this event was Ms. Mailing.
No, she was
Yes,
she was able to hear things.
right, some perception. And she was able to hear for 30 to 60 seconds, as she described it, some arguing that was going on. And then she came to the window and she saw people positioned in front of the squad car.
So, Your Honor, that's based on
Based on what?
based on
Her testimony.
based on a timing question on whether or not they're able to say specifically the timing of when the beginning occurred.
Well, based upon the testimony from Mr. Fredericks, you have a pretty good idea as to when the various videos started compared to her video and what she was able to see and so on.
Her video did not start until after the event, Your Honor.
No, I know, but the whole thing synced up in terms of timing. Anyway, so she clearly was perceiving something before Ms. McDowell got there, for instance.
Your Honor, I don't think that's clear from the testimony. I mean, Ms. McDowell says she pulled up and saw it from the beginning when he's on the sidewalk.
Yeah, but
There's nothing from Ms. White that indicates that she saw him in the intersection or heard them in the intersection prior to McDowell being there. She just happened to look out the window, and when she looked out the window, that's when McDowell was on.
Well, let me read you from my notes, because I'm not,
May I just interject one moment?
well, you can.
Can we have Mr. Ryan step outside if we're going on factual?
Sure. Mr. Ryan, please step outside. We'll be calling you in just a couple of minutes. Thank you, sir. She said that she was at home about 11:30. She finished shutting down the house, went to lay down, heard a noise. It would continue for 30 to 60 seconds, so I got up, looked out my side window. I had to kneel on my bed to look out. I saw a police vehicle. I saw a man and two police officers standing in front of the vehicle. I heard two people loudly speaking. I couldn't understand what was being said. My windows were closed. I have single-pane windows. I saw one officer in uniform. He was trying to grab the man in civilian clothing. The man twisted and pulled away. The officer said, "Stop." The man fell down in front of the police vehicle. My view was partially obstructed. I looked away and attempted to waken my fiancée. Then I heard a woman's voice shouting something like, "What are you doing? Stop." She was yelling toward police, then backward towards someone behind her. That's clearly Miss McDowell she's describing.
Your Honor, both both Ms. McDowell, Ms. McDowell, Keon, and Mr. Cowden all testified that they saw the defendants get out of the car. So that would be before Ms. White started noted her observations. Further, she indicates by the court's own notes that at 11:30 she was shutting down the house, and all this, when she made her observations, was after 11:30.
Well, I am suggesting to you that she couldn't have been sitting there for a half a minute to a minute, looking out, seeing those folks, and so on, and then hear Miss McDowell. And Miss McDowell had been there for longer than that. We know she wasn't.
Ms. McDowell testified that she pulled up and the car was at.
Right, but both within a very short. But she didn't see anything until she saw the light change, and then she gets out of the car and she immediately gets the phone going.
She saw the
And we have the time
defendants
on
get out of the vehicle.
That's
And-
what she says, yeah.
Which would be closer in time to the beginning of the incident than Ms. White's testimony.
It seems unlikely, but anyway.
Ms. Nicolava suggesting that the LVNR is relevant to the felony murder. Their experts have testified that that didn't have any impact on the cause of death. Their experts have said the cause of death is positional asphyxia from downward pressure post-restraint. And so it's not in course or furtherance of an LVNR.
Well, we're going to get into that argument later on, but I suppose, and I understand the defense point of view about this, but there's the state's point of view, which is that that is the defendants essentially were in the course of a second-degree assault, let's call it. They've got a couple other felonies they've tossed in here, but a second-degree assault that ultimately produced the death of Mr. Ellis as a result of potentially conduct by other people.
And that gets back to my Napstead motion. So
It gets back to your Napstead motion, so I told you, we've been through that.
I just want to address it when the state reps second.
Well, I'm not surprised, but, but that's why the state is allowed to connect these things, or attempt to. So, I'm going to allow Mr. Ryan to testify as to his standards, and you can cross-examine him about to what extent they don't comply or don't connect with what the folks are in Tacoma are being taught. And he is apparently willing to concede that if the Tacoma standard was different, then that's the standard that applies. So presumably Mr. Ryan will do that too when he testifies. All right, anything else we need to talk about? Okay, let's have Mr. Ryan back in. Let's have the jury. Welcome back, everybody. Please be seated. Okay, Ms. Nicolavo, you're next witness.
Your Honor, State Call Mr. Jack Ryan.
Yes, sir. Please come right up there and raise your right hand to be sworn. Solemnly swear or affirm that your testimony in this cause will be the truth, the whole truth, and nothing but the truth.
I do.
Thank you very much, sir. Have a seat right there. Please state your name and please spell your name.
John J. Ryan, R-Y-A-N.
Mr. Calavo.
Good morning, Mr. Ryan.
Good morning.
Could you please tell the jury what your current occupation is?
Yeah, so I do a number of things. I do provide training for police officers around the United States at various levels. I do audits of agencies, sometimes because they get into trouble and they need someone to take a look at operations practices. I also write policies in, I think, 23 or 24 states now for law enforcement entities. And I also get involved in litigation, whether it be mostly civil, but sometimes criminal litigation related to police practices.
And you said that you audit agencies. Is that regarding law enforcement agencies?
Yes, it's always law enforcement agencies, sometimes jails as well, but more the road operation of an agency.
And where are you currently employed?
So I'm an independent contractor for a group. I think the corporate name is Law Enforcement Risk Management Group, but we've been going for years by a acronym LLRMI, Legal and Liability Risk Management Institute.
And what's your title there?
So I'm a co-director.
How long have you been with RMI? Sorry.
Well, the company that owns it changed hands at one point, but I've been working with LLRMI, and it was PATC at one point. Now it's Law Enforcement Risk Management Group, same group of people, since 2001.
And what are your duties as the co-director?
So again, all of those things that I just said, I provide law enforcement training around the country. I review training of other instructors that we bring on board. I get involved in these audits of agencies. I get involved in all of the policy projects. If any new curriculum's developed, I generally review that before it's brought on the road nationally.
And what educational background do you have?
So I have a bachelor's degree in administration of justice from Roger Williams University in Bristol, Rhode Island. I have a master's degree in administration of justice from Salve Regina University in Newport, Rhode Island. And I have my law degree from Suffolk University Law School in Boston, Massachusetts.
When did you obtain your law degree?
In 1994.
And as part of your background history for employment, were you ever employed as a law enforcement officer?
I was in Providence, Rhode Island for 20 years.
What positions did you have as a law enforcement officer?
Started out like everybody as a patrol officer, was a detective for a short period of time, and then made the rank of sergeant and went back to uniform. Was a sergeant in charge of a district for a number of years, and then made lieutenant, and then was responsible for command of the whole city. And at some point I was the director of training for the department, and then I was named the department spokesman and executive officer at one point, and was a captain by the time I retired.
When did you retire from law enforcement?
June of 2002.
So you obtained your law degree while you were a law enforcement officer?
Yeah, actually all of my education was while I was working.
And you testified that currently a large part of what you do is train law enforcement officers. Approximately how much of your time is devoted to training officers?
Yeah, so, probably pre-pandemic, I probably went out on the road 40 weeks a year. Now, sometimes that would only be for a couple of days. Sometimes it's for a whole week. I was in Ohio, I think 2 weeks ago, and I did 4 different cities in 4 days for different sheriff's offices in Ohio. that came together regionally in 4 parts of the state. I think probably this year I'm on tack for maybe 30 or 35 weeks, I would think. I haven't done the math, but I think that's about where I'm at.
Can you give the jury an overview of the subjects that you train officers on?
Yeah, so I train on, I always refer to it as the high-risk critical tasks. So it's things like use of force, it's things like SWAT, it's things like pursuit and emergency vehicle operation, those tasks that tend to create liability but also create danger. So search, seize, and arrest is another one. I do a force certification class, for example, where I certify force instructors around the country. I'm getting ready to do, this is the first time I'm doing a new curriculum for certifying. It's an instructor development certification that I'll be doing for the Tennessee trainers here in a couple of weeks. So a variety of areas that I train.
And on the areas that you do train, does it also include officers' interaction and response to people that are dealing with either emotional or mental health crisis?
Of course, yeah. So that's one of the high-risk critical tasks, is dealing with the mentally ill or dealing with persons of diminished capacity, whether it's because they're just simply emotionally disturbed, whether it's a substance abuse issue, whether it's mental illness. So there's a variety of things that can put persons into a diminished capacity and into crisis.
And over your career, have you also been published in certain areas?
Yes, so I've got a lot of articles that are published through LLRMI. I've also got several manuals and a couple of books that are published through LLRMI. I've also been published in various law enforcement periodicals as well.
And in general, what subject matters have you been published on?
Again, the focus is always on these high-risk critical tasks. So it'd be things like search, seizure, and arrest. It'd be things like emergency vehicle operation. It'd be things like use of force, special operations, being SWAT, and things of that nature. So always the high-risk critical tasks.
And you mentioned several different cities and states in which you've done trainings in. Have you also trained in the state of Washington?
I have.
And are you familiar with the law enforcement policies and procedures that apply to all officers in the state of Washington?
Well, I'm certainly familiar with, obviously the state of Washington has to follow, for example, in use of force, what is developed through the United States Supreme Court, because everybody in the country has to follow that. I'm also familiar that there's a statute on point in the state of Washington that says that force has to be reasonable and necessary.
And in your prior trainings here in the state of Washington, did that focus on the high-risk arrest and the use of force?
Well, yeah, I would say that every program that I ever did here, in fact, incorporated use of force. I know I looked it up. The last time I was here was 2016, and I did a program for SWAT officers at the State of Washington Tactical Officers Association.
You testified earlier that part of your work as an independent contractor, does that include doing like expert witness testimony as you're doing today?
Everything that I do through that company, and it includes looking at cases and providing expert testimony if I'm asked to.
And approximately what percentage of your work includes doing that?
You know, I don't break it down. I don't break it into different buckets, if you will. But I would say probably somewhere to 50 to 60% right now, particularly post-pandemic.
And do you testify in both civil and criminal matters?
Yeah, more often than not, it's civil, but I have testified in a number of criminal matters over the years.
And in general, are you able to break down how often or what percentage it would be approximately that you represent defendants?
Civil or criminal?
Why don't you give us civil first?
Again, I'm told this generally by attorneys because they run my numbers. I'm usually...
Sustained.
Based on your knowledge.
I don't think got an answer, so if there was an answer, it should be struck.
Based on your personal knowledge, approximately how much of your, or what percentage of your testimony and consultation is in representing defendants?
70 to 85%.
And is that typically law enforcement agencies and officers?
Agencies and officers, yes.
And on criminal matters, what percentage of your consultation and testimony is for defense?
I've always only been on the defense side until this case.
So this is your first time testifying for prosecution?
Yes.
And when you say that you've only been on defense side, is that typically again for law enforcement officers?
Yes.
Do you recall how you came to be retained on this case?
You know, it's typical in every case, but I got a call from an attorney who asked me if I'd be willing to do a review of materials, and that's essentially how it always starts.
Do you recall approximately when that contact took place?
I don't. I think another attorney made the referral, like through an email or something, and the next thing I know, I got a phone call. I don't recall how that was set up, though.
Do you recall the first attorney from the state that you had contact with?
I believe it was Miss Eakes.
And are you compensated for your work on this case?
Of course.
And does that compensation have any impact or affect your opinions at all in this case?
Absolutely not.
What were you hired to do as far as the scope of work on this case?
You know, I was hired to review materials, which includes a number of different things, everything from videos to statements, things of that nature, anything to do with the investigation itself, and then see if there's anything that I see in those materials that I can offer opinions on that would assist the jurors in understanding the police practice related to the events.
You said that you reviewed a number, part of the scope of your work was to review a number of materials. Did that include going through policies and procedures for Tacoma Police Department?
Yes, I did go through some of their policies and procedures, absolutely.
And also trainings from Criminal Justice Training Center?
Yes,
And also include going through North Carolina training for law enforcement, Defendant Burbank?
yes, it did.
And you also go through the video evidence that was available
I did.
in addition to civilian statements
Yes,
and the statements of the defendants?
yes, I did.
You also review a number of police reports and interviews of police officers.
Yes, I did.
And did you also review interviews of the fire personnel?
Yeah, there were a number of statements from fire personnel as well.
And did you familiarize yourself with a sync timeline video and audio that was prepared by Mr. Grant Fredericks?
I did. I saw the materials prepared by Mr. Fredericks.
And did you also have the opportunity to review Mr. Fredericks' testimony from this trial?
I did. I don't have it committed to memory, but I did review it.
I want to ask you some questions about training and the requirements in the state of Washington to become a law enforcement officer. Are you familiar with what's required here?
As a general matter, yes.
And where does that training generally occur?
At the Law Enforcement Academy, I think the basic academy is, my memory is 720 hours.
And when you say 720 hours for the basic academy, is that for a new officer?
That's for a new officer, yes.
In this case, was Defendant Collins a new officer when he was initially employed by TPD?
No, he was what we call a lateral transfer. So, agencies will sometimes bring somebody from another location, whether it be another state, whether it be another agency within the state, and they become a lateral transfer.
I think I misspoke. I was asking
Oh.
about Defendant Collins.
Oh, I'm sorry.
That's okay. It's instead of Defendant Burbank, but Defendant Collins, was he a new hire?
Yes,
And what about Defendant Rankin?
same thing. He was a new hire.
So that would have been required for both of those to go through the 720 hours.
Yes.
And then Defendant Burbank, I think I interrupted you with.
Right. So he was a police officer prior in North Carolina. So he went through the 80-hour lateral academy. I think it's 80 hours.
And is that commonplace to have a lateral just go through a shortened time at the academy?
Objection, Foundation.
Based on your knowledge?
If he knows. Yes.
It's fairly typical through the whole United States that takes place. There's a shortened academy for people with prior law enforcement experience.
And based on your knowledge, what general areas are covered in the 720 basic law enforcement?
Well, in the 720, obviously, you know, things like use of force, search, seizure, and arrest. I'm certain there's a crisis intervention training that's required here in the state of Washington as well. So there's a number of different topics, but they focus on the critical tasks. Obviously, there'd be driving, firearms, all of the tasks that law enforcement trains through the United States.
That include like the arrest procedures and the legal standards that would apply?
Correct. When I said arrest, search, and seizure, absolutely. Yeah.
And first aid and issues of health risks to citizens that come in contact?
Yeah, so officers are trained as first responders, so they'd be trained on first aid, CPR, things of that nature as well.
And with those arrest procedures that you mentioned earlier, would that also include the prone position and restraint?
Your Honor, can we just have a foundation as to what he's referring to?
In what regard?
Answer broad-based as opposed to specific training in Washington. I'm on the same page.
Well, I don't see any problem with the broad-based question, just at least for the moment.
That also will include the prone restraint and prone position.
And absolutely should, yes.
And based on your knowledge and review of the materials, would it also include that being a temporary position?
I object to continuing the nature of these questions, Your Honor.
It is leading.
It's foundation, Your Honor, for the policies in place, the procedures in place, and the training.
It's still leading.
What would be taught regarding the prone restraint position?
You know, prone restraint is recognized as can be dangerous, particularly prolonged prone restraint. So because of that, we train to immediately get the person out of prone restraint once they're handcuffed. That's training that's been around for years and years.
And Mr. Ryan, do you recall specifically when each defendant graduated from or became certified through the academy?
I do not.
Would it assist you in recalling those dates and reviewing the training history report for each defendant?
Absolutely.
Commissioner from Schroeder. And Andy, what's been marked as State's Exhibit number 56. You can take a look at that. Have you seen that before?
I have.
And who is that regarding?
This is Officer Burbank.
And when did he become certified, State of Washington?
It looks like December 1st, 2015.
And Andy, what's been marked as State's Exhibit number 63. And have you seen that previously?
Yes.
And who is that regarding?
This is Officer Collins.
And when did he become certified law enforcement officer in the state of Washington?
You know, it also looks like 2015. It looks like he got his certification on November 5th, 2015.
And you testified earlier that the officers, the defendants in this case, are required to go through CIT training, which is the crisis intervention team training. Does that document in front of you also indicate the annual training being completed for that?
It is. It's annual crisis intervention training.
And I'm going to hand you back 56. Does that also include for Defendant Burbank that he's completed the crisis intervention training?
It does, yes.
And then Exhibit 69, you've seen that before?
Yes.
And who is that regarding?
This is Officer Rankin.
And when did he complete his training and certification to become a law enforcement officer?
It looks like August 6th, 2018. That's the active date on this one. It doesn't have the certified peace officer date like the others had. The same spot.
Is it listed as being current?
Yes, as of August 6th, 2018.
Thank you. Does it also include additional training that he went through,
Yes,
completed post that date,
yes,
including the crisis intervention?
yes.
And you testified that Defendant Burbank had been an officer previously in North Carolina. You reviewed the materials from his training specifically from there?
Yes, I reviewed a number of different trainings from the Basic Law Enforcement Training Academy in North Carolina.
And do you recall reviewing the in-custody transportation lesson plan that he received?
Yes,
And do you recall what that entailed?
Maintain my same objection.
Your Honor, I can ask a follow-up question then.
Please do so.
The training that Defendant Burbank received at North Carolina training, is that also consistent with the standards and training in state of Washington?
Your Honor, well,
If you know, sir. Answer.
it certainly should be.
And based on what you've
maintain my
reviewed,
objection.
Hold on.
based on what you've reviewed, particularly regarding, there's a lot of different areas to go through, but particularly to start with regarding positional asphyxia, is that consistent with the statewide training?
Yes.
And continue, Your Honor.
May I report here, Your Honor?
You may.
Good morning, Mr. Ryan.
Good morning.
You said it should be similar in nature from North Carolina to the state of Washington.
Yes, sir.
Do you know specifically what's taught in the state of Washington?
I would have to have it in front of me to see if specifically what it says.
So, I mean, as you sit here, you can't say that there's any differences or they're the same between North Carolina and the state of Washington, is that correct?
There certainly should not be.
Well, that's not my question. As you sit here, you can't say specifically that they are the same.
Not without having the lesson plans from Washington in front of me.
And of course, as you indicated, Officer Burbank, at least in Washington, would have received a different type of training, or at least a procedure-wise, based on him being a lateral from North Carolina, as opposed to people who, Rankin and Collins, for instance, who their first job as an officer is in the state of Washington, correct?
He would have, obviously 720 hours is different than 80 hours, so yeah, of course.
And what's incorporated in that 80 hours that Officer Burbank received, you don't know, as you stated today, is that correct?
Again, I'd have to have those documents in front of me.
I have the same objection, Your Honor.
Sustained.
Mr. Ryan, did you review the CJTC, the Criminal Justice Training Commission, PowerPoints and lesson plans for the time period in which Burbank, Collins, and Rankin were attending the CJTC?
I did.
Did you note in reviewing any of those, anything that contradicted the training that Defendant Burbank received regarding positional asphyxia in North Carolina?
I did not.
Your Honor, maintain the objection because he doesn't remember. And
Wait, you're asking a different question now. You asked him before about in-custody transportation plan training.
That's
Now you're talking about positional asphyxia.
positional asphyxia is included in that.
Am I supposed to guess this? That's not what the questions were. You have an
the
objection?
other part of it is by wording the question the way it's worded, knowing that she knows that the training training that Mr. Burbank received is different from
Objection, Your Honor.
in the state of Washington.
Your Honor, it's improper, it's not accurate.
Hold on, hold
It
on,
shouldn't be-
hold on. Both of you. Excuse the jury for a few minutes while we discuss this. Ladies and gentlemen, please do not discuss the case. Okay. Be seated, everybody.
We didn't witness the major, I don't know.
Sure. Excuse us. Again, Mr. Ryan. So finish your objection. Finish your objection, Mr.
So,
Frick.
Your Honor, she's incorporating this all together as if the training is similar in nature, as opposed to potentially overlapping. Acknowledge that he's got 80 hours, they had 700 plus hours, or whatever the number was. So it's totally different. And then secondly, they have an exhibit up here that.
Well, I assume he got 80 in Washington, is the way I understood this.
Correct.
He may have gotten, I don't know how many in South Carolina.
I get that, but if you're gonna say, you're gonna lump them in together and they got the same training, they definitely didn't get the same training. Secondly, there's an exhibit that they have here as far as my client, Officer Burbank, being certified and becoming an officer in the state of Washington. It says what time or what year he received his official status in this state. You look at the document.
It's Exhibit 56.
I believe it is, but there may be another exhibit. It says he attended the 80 hours. There's no listing of classes that he attended. There's zero, what I saw, unless there's another document I'm not aware of.
I didn't offer it to be used as a curriculum of everything that he was taught. It was given for the dates.
Yeah,
That
well,
is-
what's the curriculum?
No, but the next thing we were doing is you're going to say that he had reviewed the PowerPoint lesson plans and going to talk about that in connection with these defendants. I guess no, jeez. What? One of the things that sort of bothered me about all this is I don't know how Mr. Ryan's going to try to establish that even if there was a violation of police training in some way, that it contributed to the death of Mr. Ellis. I mean, I've heard the thing about tasers and the LVNR. The business is putting the person in and out of a prone position as quickly as possible. That of itself, if we want to talk about it, is not necessarily a big deal one way or the other, in the sense that Mr. Rankine himself testified that, you know, through his statement that was provided, not his testimony, that he rolled him over on his side in order to avoid having him on his stomach, for those kinds of reasons, right?
Your Honor, Mr. Rankin's statement, which is the evidence and the things from his testimony, includes that he rolled him over to do a weapons swing.
Right.
When that was done, he then put him back in the prone position.
Yeah.
When he was hobbled and connected to four-point restraint and handcuffed, and Mr. Rankin's own statement includes that he put all of his weight, in his own statement, he says he put all of his weight
Right.
across the back of Mr. Ellis. He also then later says he puts his knee under at the base of the neck and at the middle of the back and maintain that position after checking him for a weapon sweep. He also says that he doesn't put him back in the recovery position until after fire is coming up. So on scene, walking up, that's when he puts him in the recovery position. And so it's 8.5 minutes. of
Well,
him
it's probably closer to 6 or less, right?
Either way, Your Honor, the testimony from Mr. Ryan will include that the training, and as evidenced by the officers noting the recovery position and the need for it, the training is consistent, that they are not to have weighted their weight on the back of somebody that is in the prone position. And they are trained not to do that because it can lead to hypoxia, it can lead to positional asphyxia, it can lead to increased need for oxygen, it can lead to an increased heart rate, all of which ties into the cause of death for Mr. Ellis.
Right.
Furthermore,
But
he's
what,
going to testify-
wasn't there also additional testimony from this Officer Rankin that he told him to calm down, that he did calm down, that he rolled him into the recovery position, then he started to continue to resist in a way? And so he put him back on his prone position?
And then he put his weight back on him, and the testimony.
Right, but that was in the middle of all that too, right?
He only did the recovery position twice, Your Honor. That was it.
Once for the weapon sweep, and once later on.
Once for the weapon sweep, and once for when fire was coming up.
Well, but no, but he said, did he not say that he put him back in the prone position when he became difficult? Maybe that was after the weapon sweep, I don't know.
He says he's there with the officers, no other officers have arrived, that they're struggling with Ellis. He goes, Burbank gets bucked off. He then puts all his body weight on him to make sure that Ellis doesn't get up. They remain in that position until other officers arrive. Once other officers arrive, they get him in hobbles. He says, I don't know who puts him in hobbles. I'm dealing with him. Once they get him in hobbles, he puts him in recovery. He then does the weapons frisk. He then he removes the probes as well, which takes time, right? Then he starts thrashing around again, and he says, we put him back into the prone position, and he says, just to hold him there until fire arrived. He doesn't describe putting all his body weight on top of him or kicking his ankles out like he very descriptively said previous. So one of the issues here is the state keeps manipulating what he's saying to fit their version of events when it's not what he says. And I expect that that's what this witness is going to do as well, and we should just have him read from the actual statement itself instead of manipulating it in some way that fits their narrative.
Well, that's another issue.
So then he puts him back into the recovery position again, and they're talking to him and monitoring him. I mean, it's not just him in a vacuum. It's Officer Ford that's sitting there looking at Ellis saying, come on, man, breathe. Fire's on the way. I mean, it's a team collective effort that they're doing with this individual.
Well, the issue had to do with training plans and lesson plans and so on.
Your Honor, the training is, if they disregard their training, it goes to the element of recklessness, which is the state is required to prove. And Defendant Burbank is a lateral. He's expected to take the same training that he had with him at North Carolina and take that to the state of Washington when it comes to the medical aspect of it, of positional asphyxia. And he was trained specifically on positional asphyxia and the risk that it has to a suspect. And
I
the
know,
state-
but isn't it interesting that we've heard from the medical doctors that some of that isn't quite so serious as we think? Well, anyway, I think what I'm going to do here is I'm going to go ahead and let Mr. Ryan testify with respect to this, and the defense can cross-examine him with their heart's content, but he's going to be at least able to say how this should be been handled appropriately. I don't know that you need to get into, I don't know that it's appropriate to get into what individuals were trained on specifically, simply because you don't know. None of us is going to know. Somebody could have stepped out for a cup of coffee in the middle of the training, I don't know.
Your Honor, these are general standards that all
That's right, he's going to say what the standards are. And he can say to what extent he thinks there's a deviation here. And they can cross-examine after that if they care to. But getting into the details of the training, when you don't know what it is, and you're never going to know what it is, for sure, is that. But this is what an officer should be doing in the field.
And Your Honor, the training that we have, so just so I'm clear, we can go through the North Carolina training with them on what.
I don't want you to go through any of the training of it. These are the standards. This is what an officer should be doing under these circumstances. You can say it's based on training generally, but you don't know what it was trained in North Carolina on that particular day, neither does anybody else. And nobody knows whether or not Officer Burbank, in this case, was even in the room when the time it happened. Presumably was, but who knows? If it was a legal malpractice case, he wouldn't talk about this guy took evidence law. You'd say this is what a lawyer should be doing in the field. You didn't do it. And you can say the same thing here. That gets you to your case without the details of the planning that we don't know, or the training which we don't really know. And you're never going to know. So it seems to me you're allowed to put your case on that way. And if they want to say there's something different in the training, then that's up to them. Or in the standard, that's up to them.
Your Honor, can I have a few minutes before the jury comes, one to speak with the witness and two to reorganize a few things?
How much time do you need?
5 to 10 minutes.
10 minutes, really?
5 minutes, Your Honor, please.
It'll take us 2 minutes just to get the jury here. Let's just have the jury. Bring the witness in.
Please invite them to the room, please. All please rise.
Okay, welcome back, everybody. Please be seated. Mr. Glava, when you're ready.
Mr. Ryan, what is the standard training or principle for when an individual should be in the prone position?
So, you know, we tell officers that if the person's dangerous, to put them in a prone position to accomplish restraint. But then once handcuffing is done, to immediately get them off their stomach for purposes of facilitating breathing.
And you say for purposes of facilitating breathing, what is the standard concern about if they're left on their stomach?
So, the concern for a person on their stomach that's handcuffed is that their breathing will be impaired. They can't get their lungs to open enough and close enough, and so that's what the training is. And so the concern is they could not have enough oxygen.
And are you familiarized with the term positional asphyxiation?
I am.
And is that a condition that is taught, is standard taught throughout law enforcement?
Objection, leading by the foundation.
It's been taught to law enforcement for decades.
And can you tell the jury what that is? Explain to the jury what it is.
Objection, foundation, made known form of question.
Overruled, you may answer.
So the training is that the second somebody's handcuffed, you get them either into a side position so that they're off their stomach, so you can put them on their side, particularly if there's any resistance continuing, or seat them upright is another position. We call it either the recovery position or the rescue position. And again, it's to facilitate breathing so that they're not impaired by staying on their stomach.
And when you add a hobble to the equation, does that also increase that risk? Or how does that impact, I'll rephrase it. When you add a hobble to the prone position and handcuff behind the back, how, if at all, does that increase the risk?
Your Honor, I'm projecting, because I think this is through the medical testimony, and that's beyond his knowledge.
Or this is
As far as, the question is how does it increase the risk? That is kind of a medical question. You can ask this question in general in terms of how does adding a hobble to the equation, I think as you put it, change anything here?
Well, that route, how adding a hobble to the equation, how does that change anything for law enforcement?
Again, from a law enforcement training perspective, it just makes the position even worse, particularly if the hobble cord is not only around the ankles, but then it's connected to the handcuffs, because it pulls them further up onto their stomach in a way that will impair breathing.
And to your knowledge, is there a TPD policy that prohibits officers transporting someone in the prone position with a hog tie?
Objection to the relevance of the transport policy. And I join.
Sustained.
Based on the training and your knowledge, why would you not leave somebody in a hog tie position, hobbled, and in the prone position?
Question asked and answered.
Overruled, you may answer.
Because it will impair breathing. It's been, this is something, as I said, it's been trained to law enforcement for decades.
And based on what's been trained to law enforcement for decades, does that also include evaluating the suspect?
Anytime we take a suspect into custody and restrain them, we're supposed to watch for signs of distress, anything that might show either injury or illness or, even lack of oxygen.
And what are the standard signs of distress for lack of oxygen,
Objection by the foundation. Medical.
if you know?
If you know.
From a law enforcement training perspective, not from a medical perspective, person tells you they can't breathe. Person shows labored breathing. Any one of those conditions. Or you don't see the chest rise and fall, or you don't see it rise and fall very much. So labored breathing, all of those kinds of things would be things that we would look for in monitoring.
And is it standard law enforcement training to include what to do with that information if you evaluate a suspect and determine that they are having difficulty breathing?
Yeah, any time a person has a stated or observable disability of any sort, then you want to get them cleared medically right away. So you want to make medical aware of what the condition is that it raises the concern.
And that's even if it's stated but not observed.
Objection leading.
Permit, you may answer.
Correct, stated or observable, as I said, yes.
And is there a concept, or what is the concept in your custody and your care? What does that mean for law enforcement?
We have, we do one of the critical tasks is care, custody, control, and restraint of prisoners that deals with making sure that they're properly restrained and that we're monitoring their condition after they're restrained.
And that is across the board for law enforcement?
Yes.
I want to ask you some questions about the force and use of force. Actually, before I get to that, is there also standards across law enforcement for contacts with suspects
Yes,
and contacts with citizens?
of course.
And with that, are there social contacts?
Yeah, so there's three basic types. There's social contacts, or we sometimes refer to them as consensual contacts. Then there's reasonable suspicion-based or Terry-based contacts, and then there's arrest contacts.
And on the consensual contact, can you explain to the jurors what that means for the citizen?
Yeah, that's a situation where the police officer has no evidence to support detaining somebody against their will. But certainly officers are always encouraged to talk to people. And the person can decide not to talk to the officer. And the officer has no power to detain them if it's this kind of social contact or consensual contact. But an officer can walk up to anybody in a public place and have a conversation with them. That person then can choose whether or not to stay or leave. One of the things, though, is we look at the officer's words or conduct to see, because that's the changing point, whether or not a reasonable person would feel free to leave or not.
And when you talk about being free to leave, are you familiarized with the term proactive policing?
Of course.
And are you familiarized with that term as far as TPD having a proactive policing policy?
Yes.
And can you tell the jury what that means?
Yeah, proactive policing is obviously by its very nature just the opposite of reactive. We want, in a proactive approach, you actually go out and make contacts with people. And you're always looking for potential criminal activity, but even social contact, you might be trying to develop social capital with the community. So you want to go out and be very proactive as opposed to just responding to calls and things of that nature. So proactive would mean, middle of the night, you see somebody walking down the street, maybe stop and have a conversation with them without making demands that would make them feel that they weren't free to leave.
And you said that there's a Terry stop. Can you explain what a Terry stop is?
Yeah, so, the Terry stop is something short of an arrest, where officers have reason to suspect that there's criminal activity, but they don't have enough to arrest. Many years ago in an old case, Terry versus Ohio, which is where it comes from, Detective McFadden in Ohio.
Well, Your Honor, I would object this.
Well, I don't know that it's unresponsive, but it is elaborate. Maybe more than we need to know.
If you could tell us what a Terry stop standard is.
Yeah, so the standard is that you don't need to get to enough evidence to arrest. You can get to just what they call reasonable suspicion of criminal activity rather than probable cause to arrest, and that gives the officer some authority to stop the person, even in some cases use force to stop the person, to confirm or dispel their suspicion through investigation. So they get to stop them. They don't get to transport them to the police station or anything like that, but they get to stop them on the street, have a conversation, and try to confirm or dispel suspicion of criminal activity.
And you mentioned probable cause. Can you explain what's meant by probable cause?
Yeah, so that's the evidentiary standard that an officer needs to meet if they want to take somebody to the police station for criminal charges. They have to, before they can transport them, they've got to get enough evidence. I always use a measuring cup, if you will. So reasonable suspicion would be the first line, and then probable cause would be the second line in the measuring cup. And the officer's got to put facts and circumstances into that cup and get to one of those lines. If he gets to reasonable suspicion, he can make a stop, or she can make a stop. If they get to probable cause, then they can actually transport the person to the police station under arrest.
And Mr. Ryan, you were talking about the case law, is there the standards and the trainings and everything that you're testifying to today, is that based on the Constitution and case law?
Yeah, that's the same standard that applies throughout the United States. Remember that a state can be more restrictive on officer power.
Objection, narrative, potential, non-responsive, foundation.
As to the last sentence, yes. The rest of the answer was responsive. That stands.
And all the principles that you testified to today, those are also applicable to the state of Washington?
Absolutely.
And your opinions are based on the state of Washington laws?
Objection, lack of foundation.
Give me answer.
Yes, I mean, I'm certainly familiar with some of the laws and certainly consistent with it.
And I want to ask you about the initial contact that Defendant Burbank and Defendant Collins had with Mr. Ellis. Were you asked to review that initial contact?
I was.
And based solely on Defendant Burbank and Collins' perspective, were you able to come to an opinion on whether or not that initial contact was lawful?
Your Honor, I would, it's a compound question, number one. It's two officers.
Well, I don't think that makes it a compound question. Was there another objection?
No, Your Honor.
Overruled. You may continue.
Yes, so based on the version of events that the officers have stated, they certainly would have had reasonable suspicion to stop, and they would have had probable cause to arrest if Mr. Ellis, for lack of a better term, came at them in the car unprovoked, as they've reported, then they would have absolutely had sufficient information to stop and to arrest, in my opinion.
Did you also review the civilians' accounts from Ms. McDowell, Keon Lowry, and Mr. Seth Cowden?
I did.
And the video evidence from the Vivint camera and Mr. Cowden and Ms. McDowell's phone?
Yes, I did.
And in reviewing the civilian statements, did you have a different opinion that you reached regarding that initial contact was lawful?
Yes, if you were to adopt their version of events, then there wouldn't be any reason to stop him. And again, being the version of events that he just simply was crossing the street, was maybe called back to the police car and then started walking away, and then suddenly there's this unprovoked going after him. So under that version,
Strike, not lack of foundation.
Overruled.
under that version of events, I would say there would be no reason to stop and no reason to arrest.
And is your role here as an expert witness to determine a credibility of the accounts?
No, it's not. That's up to you.
I want to move to use of force principles in general. And again, the testimony that you give today is regarding the standards across the state.
Yes,
And you've also reviewed the TPD use of force policies?
I have.
And when you reviewed the TPD use of force policies, those consistent with the standards across the state?
Across the state and across the country.
Can you tell the jury what the different levels of resistance are?
Yeah, so, some agencies go further, but it's generally, no resistance, so a completely cooperative person. Then there's passive resistance, and there's active resistance. Then you might see assaultive resistance, and then you'll see, a situation where it's a deadly encounter.
And what do you mean by passive resistance?
Passive resistance, we see it a lot in protest cases, by way of example, where the person just sits down on the ground and just doesn't comply at all with verbal commands, for example, of the officer.
Can you give an example of active resistance?
Yeah, active resistance can be across a wide range. So, you could have a very low-level active resistance, perhaps just pulling away from the officer when the officer tries to grab a hold of the person, all the way to a very serious active resistance where the person arms himself with a weapon to try to escape from the officer or otherwise hurt the officer.
When a suspect is suffering from air hunger, are there signs that are to be misinterpreted? Are there signs that indicate that person is fighting for oxygen versus resisting?
Objection, foundation,
Your Honor,
leading.
I objected beyond this.
Sustained.
Mr. Ryan, in your training and experience and the training of others, are there specific signs for an individual that law enforcement is to look for when an individual is potentially suffering from ear hunger?
So, one of the things that I train, and I've been in trainings where it is that sometimes a person is fighting for breath because they're not getting enough oxygen. And so their actions are involuntary as opposed to voluntary. They're not
Foundation of the strike.
they're not consciously trying to resist the officers, but instead they're so hard trying to get oxygen that they're making involuntary movements to try to do so.
Objection, same basis.
That's your stand.
And based on your training experience, can that also include trying to lift the chest up off of the ground?
Well, that makes calls for speculation.
His
Lifting his chest up off the ground? I would say it's leading, for one thing. You might ask him generally how would this manifest itself?
Certainly, Your Honor, I can go that direction. How would it manifest itself?
It could be twisting and turning. Any movement to try to get the weight off the stomach would be consistent with a person trying to get oxygen in a case like this, is what we train.
Object, same basis, it's stated by all counsel.
Overruled.
hear the rest.
I object, previous bases as stated by all counsel.
Overruled.
Sorry.
On the same basis.
Yes, thank you.
Continue.
You inform the jury of the different types of resistance. Can you also inform the jury of the different types of force that can be used?
Yeah, so agencies throughout the country, in fact, Tacoma has some force options. We recognize that at the first level is something called officer presence. Officer presence is just the officer showing up in uniform. In many cases, the minute the person sees law enforcement in uniform, they automatically comply their behavior to what's expected under the law. I could give you an example if you like, but for example, a person's driving down the highway and going a little bit faster than the posted speed limit. All of a sudden, they see a marked police car. What do? They step on the brakes. So again, that's an example of officer presence, just a visual sight. And then there's verbal commands. So that would be our second level, where officer gives verbal commands, and in many cases, the person will respond to those verbal commands. The next step is what we call soft, empty hand control. So soft, empty hand control is simply putting your hands on somebody, things of that nature. After that, we see with a...
I'm sorry, I missed that.
I'm sorry, what was that? I didn't hear the last word.
I'm sorry, I'm not sure what the last...
You said after soft, empty hands, what was the next level?
After soft, empty hands, we would see things like OC spray or pepper spray, things of that nature. After that, we would see things like the taser, baton, things of that nature. And then we would probably, if the agency had canine, that would be next, and then deadly force would be at the top.
When an officer puts pressure on a person, is that considered force?
Of course.
And just based on your training and experience and policies, if an individual has consumed methamphetamine, does that automatically allow for force to be used?
Objection, foundation.
It's leading.
How would one's ingestion of methamphetamine impact whether or not an officer could use force?
It wouldn't. That's not one of the criteria for force.
And are you familiar with the U.S. Supreme Court case, Graham v. O'Connor?
Graham versus County, yes.
Your Honor, it's Graham versus Conner.
I apologize.
Sorry, I just.
I put an O there, and I apologize. Happens to be a name I'm familiar with, so
Well,
thank you for the correction.
I'm not gonna edit the counsel. Go ahead.
Graham Graham v. Connor,
Yes, I am.
and how are you familiar with it?
Well, it's something I train on a regular basis, and I incorporate it into policies when I write policies for agencies around the country.
And are the Graham factors implemented across the country?
They are, both through training and through policy. Officers are asked to consider certain things when deciding to use force.
And what are the Graham factors?
So the three major factors are the officer has to consider how serious the offense is the officer suspects at the time. So there's a huge difference between if the officer suspects the person just shoplifted something versus the subject just robbed a bank. Right? One's much more serious than the other, and the government interest is higher. Second factor is whether or not the subject poses an immediate threat to the officer or anybody else present, and what the degree of that threat is. And we have a number of factors that fall under that in assessing threat. And then finally, whether the subject is actively resisting or attempting to evade arrest by flight. So that would be the third factor under Graham.
And you said there's a number of factors to consider when assessing threat. Can you elaborate on that a bit for the jury, please?
Yeah, so when assessing threat, you look at things like officer, offender, size, and ability. So we're looking at a small subject and a big officer, or vice versa. Number of officers present, number of persons present. Sometimes an officer is in a situation where they're by themselves, but there's a number of people with the person they're trying to arrest. So that would change the threat assessment. Availability of weapons. Does the subject have availability of weapons? Does the officer have resources, their own weapons, that they can use to protect themselves? So again, these are all factors that go into the threat assessment.
When considering the threat assessment, does it require that there be a specific threat?
Well, an officer has to be able to articulate a specific threat, or else if the officer can't, it's not the infinite world of possibilities, if you will. Officers have to work in terms of probabilities, not possibilities.
And is there another model besides the Graham factors that is utilized in use of force?
Yeah, so again, that's what we just kind of went through, a use of force continuum that has options available, and then essentially says, look, if the subject does A, then this is the officer's response. And Tacoma has that in their policy.
And does Tacoma, how would you describe the Tacoma policy as far as Graham and the continuum?
I think it's a hybrid policy because it includes a lot of the language from Graham as well as the force continuum. So it's what we refer to as a hybrid policy.
And the Graham factors would be applicable nationwide?
Everybody has.
I'm sorry, could you please restate it? I didn't hear the whole
Just
thing.
for clarification, the Graham factors would be applied nationwide?
Absolutely, they have to be.
Based on the policy, so Tacoma Police Department policy and the hybrid policy that you just spoke about, how does the level of force permitted change if the threat is decreased or dissipates?
Again, as threat goes up and down, an officer can escalate or must de-escalate. So it's easier to give an example. If all of a sudden, somebody maybe even committed a murder, but when the police officer chases them down, they drop the gun and they put their hands up, then no force can be used. So again, as the threat dissipates, the person is restrained, things of that nature, so is the force got to dissipate with it.
And you say as the threat dissipates and a person is restrained, once a person is restrained, what is the level of force that can be used?
Again,
It's vague, Your Honor. Lack of foundation.
I think where she's going, she's entitled to go. I'm not sure she's getting there the right way, but
yeah, again, it's,
why don't you put it into the facts of our case?
We'll get there in a bit, Your Honor. We'll move to a different area for now, and then I'll come back to that.
All right, well, then I'll sustain the objection for now.
And are you also familiarized with the state of Washington standard for force being necessary?
yeah, so it's a standard that says force has to be reasonable and necessary.
And can you explain that a little bit?
Yeah, so, the necessary requirement is that there has to be a reason. You can't just use force for any reason. It has to be necessary to accomplish a lawful mission of law enforcement. So it would have to be necessary to accomplish the arrest. It would have to be necessary to accomplish the detention.
And with that, how would the concept of other alternatives come into play?
Well, I think, that's where I was making the statement before, is that under necessary, then there's no other alternatives that are available to force. And I think,
Misstates the standard here on the foundation.
yeah, I think that's pretty close to the way it's worded. I'd have to look at it in front of me, but I think that's pretty close to the way it's worded.
And that's based on the RCW.
Yes.
What are the factors that, with that, what are the factors that officers are to consider in which method of force to deploy when faced with a resisting suspect?
Well, they're going to look at the degree of resistance, and they're going to look at whether it all goes back to, that Graham factor and what's reasonable and necessary. So they're going to go back to how serious is the offense they suspect, what's the immediate threat, and how serious is that immediate threat to themselves or somebody else, and what degree of active resistance there is.
Are you familiarized with the term proportionate force?
Absolutely.
And can you tell the jury what that means?
This might be a point to break. We're past our breaking time, so we'll take our morning recess. Ladies and gentlemen, please do not discuss case among yourselves with anyone else. Do not permit anyone to discuss case with you or you're in your presence, and we'll be back in about 15 minutes. least through the 22nd of December. And to let them know that if they want to make some plans beyond that, the week following Christmas immediately, Christmas is on a Monday this year, that we will not be in session on the 26th through the 29th if for some reason we're still at that stage. So they can make whatever plans they want to make. Anybody have an objection to me telling them that?
No, Your Honor.
I think that might reduce a certain amount of anxiety that they're probably experiencing about this. All right, so when they come back, that's when I'm going to let them know. All right, are we ready for the jury otherwise?
Yes, Your Honor.
Okay, great.
At this rate, it's probably going to be Mr. Ryan.
Yeah, well, let's assume he's not. Who else have you got next?
Kimberly Mays, and I can't remember the name of the other witness.
DNA house from the other side. So I said, there's a person from DNA house who testified about the
What DNA?
No,
You get a stipulation, we have,
the process of
I can't take more than one person.
Well, this doesn't have to be on the record. What DNA?
DNA of Hobbles. The Hobbles who tested for Mr. Ellis' DNA. And so we have asked counsel whether they were stipulating the results. Several of them indicated they would, but not all of them have.
Why do you need the DNA of his Hopples?
To show that these were the Hobbles that were the results. We're not objecting to the Hobbles. It's not an issue. It's never been an issue.
What was the exhibit number of the Hopples?
Anyway, we stipulated the DNA, I know, we didn't object to how it was coming in.
It's 100 going.
I don't think it was actually admitted, but let me check.
It was as was.
Hold on, 100 was admitted. According to my, that's,
The Hobbles were, yes.
100 is a hobble that I measured with a flexible measuring tape, said Jacqueline Franklin. 100 was offered and admitted without objection. Now, I don't remember, but wasn't, I don't know if this is, yeah, I can't remember how she got 100.
She indicated she was the WSP evidence technician locked out for her measurement.
Yeah,
Yeah, and Your Honor, my client provided it to, I think Wilkins or one of the investigators upon request.
that's what I was thinking, but I can't see it in my notes that it says that, because maybe exhibit 100 wasn't actually mentioned at the time. So I'm trying to search through a lot of notes. I can't spot it. But yes, my recollection was that he did collect it from the vehicle, and my recollection is that Officer Collins or Burbank said, I think it was maybe Officer
It was my client, Judge.
Collins said that they retrieved it from the car, used it, put it back in the car, and then got it back out for the forensic investigator, I think.
Actually, Officer Collins didn't provide it. There were photographs taken of it. Detective Peterson testified that he was sent by Detective Rothway to go take photographs of the hobble. It wasn't collected until later, and during the course of the case, the defense raised the issue of whether or not this was actually a hobble that was even used on Mr. Ellis, and so it was tested for DNA, and Mr. Ellis's DNA was recovered from the hobble. So that's the sequence of it.
All right, well, okay, I'm not sure it's much of a dispute. Is anybody disputing the DNA, that the hobble that was Exhibit 100 is the hobble that was used on Mr. Ellis? Well, I can save you a witness.
Well, we've been asking for 3, 4, 5, 6 weeks about it.
I'm glad I could help,
Well, that's very kind of Your Honor. However, the witness is on a plane as a result of not being able to get an answer from Defendant Rankin about whether they agreed to it. So
We're not in a position to know whether it is or isn't. It doesn't
well,
belong
that's the
to our
exact issue.
client.
If they're gonna contest whether it is or isn't, Your Honor, that's exactly why we're calling.
Up to Burbank and Collins, so I guess we'll defer to them, but
Well, if you're objecting to it, or you're not objecting to it?
I'm gonna defer to the other defense on whether it is or
Is
isn't.
that an objection or not an objection?
Not an objection.
Well, Your Honor, we have to prove up our case, and it sounds like.
All right, well, it sounds like you have your DNA guy then testify. I don't know how long it should take, but anyway. So then who else have you got, Mr. Lynn?
Your Honor, there's also, they just mentioned a witness, Mays. That's the wife of Cedric Armstrong, testified. I think it's cumulative and not relevant. He was the witness, of course, that had the home where Mr. Ellis had resided and where he last lived before the incident.
What's not necessary?
The testimony of Miss Mays, who's, what's her first name? Kim Mays, that's right. Who's married to Cedric Armstrong, who's also somebody that's already testified. The court's limited his testimony, as the court recalls. He had very little
Right.
relevant testimony. I can't imagine what she would have to add, so it's cumulative and not relevant.
I don't know.
Can't waste.
It might be.
I agree, Your Honor.
Is she gonna say anything other than what we already had testimony about?
She has testimony outside of what he already covered, so
Oh.
we're not expecting it to be cumulative.
About what? Did she see him later that evening?
Well, primarily, the thing that's different, Your Honor, is that Ms. Mays will say that Mr. Ellis had told her that he had relapsed and that he had used methamphetamine within a couple of days of his death.
Oh, well, that's interesting.
Yes.
It's hearsay.
Well, it's not, it's a statement against interest under.
It's not admissible. If they're gonna object to it, you're not gonna be able to get that in.
Well, Your Honor, I think we would argue that it is a statement against interest. As the court has pointed out, Mr. Ellis was on pretrial release and he wasn't supposed to be using any drugs. And he made a statement to Ms. Mays about the fact that he had relapsed, and as a result of that, she did not mute him in those couple of days around the time of this incident because of that. So I think under 804, I believe is the rule.
I don't know that that's a statement against,
Well, it's a statement against his
Interest.
interest so far as he's aware that he is under conditions of release, which includes release, as the defense has repeatedly pointed out, that he not use any drugs and or controlled substances, and that's the statement that he made, is that he had relapsed and that he had used methamphetamine.
Your Honor, that's not in her statement.
Yes, it is.
Well, the history behind the bit is a bit amusing, Your Honor, because the state did, I think, 2 or 3 interviews with Miss Mays where she indicates that she never saw any sign that Mr. Ellis had relapsed or anything like that. They don't do any of these interviews recorded, of course. We just get their investigators' notes. And then we do an interview, I believe, with Asa Lewis, the toxicologist from Washington State Patrol, who says there are no tolerance issues built up. If there's nothing built up from that, then we get an interview report indicating that all of a sudden Miss Mays, after I think a 3rd or 4th interview with the AGs, has now said, oh, Mr. Ellis told her 3 days prior. But it doesn't actually matter much at all, because Washington State Patrol toxicologist said it wouldn't matter to his determination either. 3 days prior, it wouldn't make a difference.
I don't know.
It's hearsay.
Well, I do find it surprising, given that the state seems to be in the attitude that, Mr. Ellis was a perfectly great guy and had no issues with respect to relapse until, obviously, the day in question. It's the reason why when you brought these kinds of witnesses like Mr. Armstrong to talk about how he seemed to be sober and so on, it was like,
Your Honor, I don't think that that's exactly the state has put on the evidence of what the witnesses had to say. The state has not made representations as the court has indicated. We've always known that Mr. Ellis had indicated that he had relapsed before. The issue is whether or not, there's a separate issue of whether or not the fact that he had used any narcotics would actually be noticeable or detectable to other lay witnesses. That's a separate issue. And nobody was suggesting that Mr. Ellis had not used any drugs at all. In fact, he indicated that he had slipped. And as the defense knows and the court knows, and based on everything that the defense has continually reminded the jury and the court, Mr. Ellis had attempted to become clean on other occasions and had not been successful at it. Not particularly unusual.
Right.
The separate question is whether or not the fact that he relapsed somehow affected his behavior in a way that caused him to, be supportive of what the officers.
So what, all right, let's assume for just a moment that it's admissible. What does it tend to prove in this case?
Prove that he did, well, it goes to the issue of what his behavior is, first of all, when or if he uses, but also goes to the issue that the defense has raised that somehow he was, and they've asked repeatedly of witnesses about this, whether or not he had not been using and had a period of sobriety and then used to make the inference that his behavior would have been a certain way. So it goes to that issue. I don't think it should be a particularly long witness, but it's an important fact under 804B3, we think it's admissible.
Well, I don't know that I've seen it in this context whatsoever, but I guess I'll read the rule. 3 says, statement against interest. A statement which was, at the time of its making, so far contrary to the declarant's pecuniary or proprietary interest, or so far tended to subject the declarant to civil or criminal liability, or to render invalid a claim by the declarant against another, that a reasonable person in the declarant's position would not have made the statement unless the person believed it to be true. In a criminal case, a statement tending to expose the declarant to criminal liability is not admissible unless corroborating circumstances clearly indicate the trustworthiness of the statement. I don't know how that last sentence applies here.
Your Honor, I'd also note that in addition to Mr. Ellis being on pretrial release with a restriction that he not be allowed to use drugs, he also, by making the statement, would have known that he could lose the housing that he was having currently if he had relapsed. So they both had the report back to the court that he had violated his conditions of release as well as the potential that he could lose his housing.
So did Ms. Mays file some kind of report that he had confessed to relapsing?
Well, she didn't have to because he was killed, but.
You said it was 3 days before.
He told her that he had used 3 days before, correct.
Well, when did he tell her this? That night?
I believe he told her on, between Saturday and Tuesday, the night that he died.
So if he told her on Saturday that he'd used it 3 days before, that means he would have used it like the previous, like Wednesday?
No, he didn't say he had used it 3 days before. I'm sorry if I was unclear. He told her that he had relapsed
Yeah.
and that he had used just in those days before. And may have said Saturday that he used. And as a result of that, Ms. Mays decided that she wasn't going to give him a UA, which is what she would ordinarily have been giving UAs. And she didn't because she was waiting. She knew that it takes at least 4 days for the drugs to kind of be out of the system. So,
Well, so was she trying to give him a UA that would be a clean UA?
no, not necessarily, but she was just in terms of her practice, because he had admitted that he had used and that he would, if he took a UA, that he would be positive. So she didn't see the need to give him another UA because he had just admitted that he had relapsed and used.
Well, I have to say the logic of that eludes me just a bit. I mean, I guess she's saying that there was no need to give him a UA because we know he would have failed, so we already know there was an issue because he admitted it. So I wanted to see if he had stopped using again, so we'd give him a UA later. Is that the idea?
Well, not necessarily. I mean, keep in mind that he died in the interim, but he
No,
told
but
her this.
but her plan for,
I can ask her what her plan was in terms of if he hadn't died, when she would have given him a UA.
all right, well, I guess you're going to have to at least brief for me how that last sentence that I read from 804 would apply in this case or not apply. You'd have to show some corroborating circumstances to indicate the trustworthiness of the statement. Are the corroborating circumstances that he had methamphetamine in his system at the time of his death? Would that be a corroborating circumstance? Could be, I suppose.
It'd also be corroborating circumstance of the fact that he would acknowledge it to the people that he's living in a house with, that is supposed to be a clean and sober house, in which he's not supposed to be using narcotics.
So I guess it depends. We may have to take it. If the defense is going to object to this, we may have to do an offer of proof outside the presence of the jury to see whether or not those circumstances were present.
Okay, understood.
Okay. Now, who else? Is this taking a call?
That's all. After Mr. Ryan testifies and depending on cross, we may renew our request to call the people from the CJTC that did the training in the state of Washington, which would be Mr. Hicks, Mr. Lee, as well as former Chief Ramsdell. So
Okay. And then,
otherwise, that's it.
all right, so you're not going to call Officer Ford or the other officers?
No, we're not.
Okay.
The 7-Eleven clerk.
No, we're not.
Okay.
Finding that.
All right, Susan, you want to tell me something? We need to be at a pause here for a few minutes. at this moment. Has some medication that they've taken. But and it's the kind of thing which could pass and she could be fine, or something that maybe isn't going to pass and she's going to have some issues and she would not be able to continue. So the thought at this moment is, should we let her take a break at this point? Maybe she had something to eat for lunch and that kind of thing would maybe help solve the problem. We don't know that she'll be able to continue again at 1:30, but we can literally make that decision then. It's 11:30 now, so we'd lose that time, but I think that's what we're going to tell the jury. So, Mrs. Winnie, you can let the jury know that they're excused for lunch. We'll recess, and hopefully everybody will be back by, before 1:30 and the jurors by 1:15. All right, thank you.